So the issue of concealed carry bans in defiance of the Bruen decision is now back in front of the Supreme Court. So let's break down what is happening. Now, really quick before we jump into this video, I want to ask you guys for a favor. Looking at some of my analytics, about 58 to 60% of all viewers are actually not subscribed to the channel. So please consider subscribing. That does help the channel to grow. And then also just consider dropping a comment down below, a positive comment. Just let the algorithm know that you support this type of 2A content, and that helps the algorithm know to send it to more people. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be talking about how the issue of concealed carry bans, specifically the one out of the state of New York, is once again back in front of the United States Supreme Court. You may recall that the Supreme Court recently granted, vacated, and remanded the case Antonyuk back down to the Second Circuit Court of Appeals for a new decision in light of what the Supreme Court said in their 8-1 decision in the Rahimi case. The Antonyuk case challenged the state's new hyper-restrictive concealed carry laws that they passed through the Concealed Carry Improvement Act, also known as the CCIA. Now, that law was passed just 8 days after the Supreme Court issued Bruen, and this law in New York was passed in direct defiance to what the Supreme Court said in that prior decision. The Second Circuit issued its new decision on the concealed carry bans, and they essentially just reissued the same decision, finding that the Rahimi case did not change the outcome of their analysis at all. In response to that new ruling, the plaintiffs here through GOA have filed for the Supreme Court to once again review this issue, and hopefully they want to end the New York concealed carry ban in the defiance of what the Supreme Court said in Bruen, and this would impact other states that have tried to pass similar carry bans like California, Hawaii, and others. Now, interestingly, in this case, large law enforcement organizations, specifically ones out of California, have now filed amicus briefs to the Supreme Court in support of GOA and Mr. Antonyuk, and they want the Supreme Court to agree that these laws are unconstitutional and need to be struck down. But after Bruen, states like New York decided to pass new laws like the Concealed Carry Improvement Act, and they did that just 8 days after Bruen, and they stated expressly that they were doing it in defiance to what the Supreme Court said. Now, that law in New York was then challenged in multiple cases in federal courts, and in a bunch of cases, there were preliminary injunctions that were granted against various aspects of the CCIA. However, the state of New York then appealed those decisions up to the Second Circuit, who was liberal and biased against the Second Amendment, and they decided to grant blanket stays against those lower court decisions. Now, at that time, this then led the Antonyuk case to make its way to the Supreme Court a couple times on an emergency basis, seeking a reversal of what the Second Circuit said. At that time, the Supreme Court didn't want to get involved because it was still in a kind of interlocutory in-between basis. So they proceeded forward at the Second Circuit level, and eventually the Second Circuit ruled in 5 of the Concealed Carry Improvement Act cases. And the Second Circuit ultimately vacated some of those district court injunctions, so they ruled against the Second Amendment. Now, in the decision from the Second Circuit, they tried to distinguish those cases and the law here from what happened in Bruen. They tried to say they didn't need to apply the Bruen analysis because Bruen was an exceptional case, and they argued that these cases here were not exceptional and that the law here operated different. Now, in response to what the Second Circuit said in those rulings, GOA then filed a second petition for emergency Supreme Court intervention. Now, although the case was still in an interlocutory posture, the Supreme Court did decide to grant, vacate, and remand this Antonyuk case back down to the Second Circuit in light of what they just ruled in the 8-1 Rahimi decision. So after Rahimi, they did say that Rahimi potentially would change the outcome of what the Second Circuit said, so they wanted to send it back down to the Second Circuit for a new decision. But after that, essentially the Second Circuit opened the case back up, requested supplemental briefs on the issue of how Rahimi maybe impacted the outcome of their decision, but ultimately the Second Circuit ruled in the same way. Now, as a result of that new decision after the GVR, this case is now heading back to the Supreme Court. On January 22nd, the plaintiffs filed for a Supreme Court review and notified the lower court that they will be seeking a reversal of what the Second Circuit said in their decision. Now, in this petition, GOA argues that repeatedly, the panel asserted that it was not bound to apply Bruen's methodology, surmising that Bruen was a case of exceptional nature, and courts maintained flexibility when examining less exceptional regulations. The panel repeated this claim no fewer than 4 times to justify circumvention of Bruen's framework. The panel cited a recent law review article that labels Bruen unsatisfying, claims Bruen places outsized importance on historical silence, and suggests judicial responses to the decision in order to read Bruen narrowly and engage in the time-honored practice of narrowing Supreme Court precedent from below. If Bruen left any question unanswered, Rahimi laid them to rest. Contrary to the panel's insistence that Bruen was an exceptional case, warranting uniquely heightened historical stringency, Rahimi confirmed that Bruen simply explains the appropriate analysis. Thus, Bruen and Rahimi established the norm and do not permit a more nuanced approach whenever a court declares a challenged regulation to be less exceptional. But the panel read Rahimi differently, casting it aside as having little direct bearing, despite being the reason behind this court's remand. Now, this petition by GOA not only outlines the clear Second Amendment precedent that should find that the New York CCIA law is in fact unconstitutional, but it also shows what links the Second Circuit and other lower courts actually go through to defy Bruen and Rahimi and not apply the Second Amendment analysis. So GOA has filed a petition for Supreme Court review, and now GOA has received some support from the California law enforcement organizations like PORAC and then also the California Association of Highway Patrolmen. So they filed an amicus brief in support of GOA's position, and they argue that by upholding the majority of the CCIA, the Second Circuit disregarded this court's warning against expanding the category of sensitive places simply to all places of public congregation that are not isolated from law enforcement and effectively declaring the island of Manhattan a sensitive place. Defying these constitutional commands, New York and California expanded long-standing sensitive place definitions to encompass nearly their entire states. Not only do these laws violate individual Second Amendment rights, they also do not address lawmakers' purported public safety concerns. CCW permit holders are some of the most highly vetted, trained, responsible, and law-abiding citizens who do not jeopardize public safety. PORAC's president Brian Marvel explained that violent criminals do not bother with CCW permits and simply carry illegally. Thus, it is no surprise that crime data demonstrates that permissive right to carry laws actually reduce violent crimes. Armed citizens do for themselves what law enforcement cannot always be there to do. Regrettably, gun-free zones without comprehensive police protection attract mass incidents by advertising that only the criminal will have guns. Law-abiding citizens will obey the law, while criminals intent on causing harm will not be deterred by the sensitive place designations. They then conclude by stating that this court's intervention is necessary to correct the Second Circuit's error in overly broadly defining the categories of acceptable analogs, thereby eviscerating any meaningful right to keep and bear arms. So it's really nice to see that these law enforcement organizations are jumping in support of GOA and Mr. Antonyuk, and they're supporting, the attacks against the New York Concealed Carry Improvement Act. They did the same thing in the Ninth Circuit against the California SB2 law, and I think there's a lot of weight in the Supreme Court seeing large law enforcement groups like this actually taking a position against these CCW restrictions and, having arguments from people like the Highway Patrol and large law enforcement organizations saying that these laws do not actually protect the public. If anything, it makes them more vulnerable, and that concealed carry permit holders are law-abiding people, they're highly vetted, and they actually are not the ones causing this harm, and ultimately, criminals aren't the ones applying for these permits. So you're not actually doing anything by restricting permits and having these broad-reaching concealed carry bans, on almost all areas in various states like California and New York. This petition sets up a critical review of a state's hyper-restrictive concealed carry ban and laws which were passed in direct defiance to what the Supreme Court said in Bruen. This case also shows a clear example of how even circuit courts are directly defying the analysis that was set out by the Supreme Court and also reaffirmed by Rahimi. And even after the Supreme Court GVR'd this Antonyuk case for a new decision in light of Rahimi, you still had the circuit court here, the Second Circuit, saying that the analysis still didn't apply. So this is something we're going to be watching closely. Like I said, this petition is now in front of the Supreme Court. Briefings are going to be submitted, and hopefully this would be a significant win against these type of statewide bans and shut down what California, Hawaii, New York, and others are trying to do in direct defiance to what the Supreme Court said in Bruen. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.